Hi everyone, this is Samidha Hegde. I'm interning with LEXIS and Company. I'm a third year law student studying in Ramaya College of Law, Bangalore, and today I'm going to be discussing about Doctrine of Indoor Management under Companies Act 2013. Doctrine of Indoor Management is a principle that evolved 150 years ago, and this came after the case of British Royal Bank versus Turquand. Now, before we try to understand what is Doctrine of Indoor Management, it will be easier if we know what is Doctrine of Constructive Notice. So remember that Doctrine of Constructive Notice is a principle that protects the company from the frivolous claims of outsiders. Now, what does this mean? This means that if any outsiders enter into any agreement or contract with the company, and remember that these outsiders have access to documents like articles of association, memorandum of association, and even certificate of incorporation of the company. All these are available in the public domain, and so it is expected that anyone who enters into a contract or agreement with the company has knowledge about this, is aware of this, and has read them. And if some person without going through them enters into a contract with the company and subsequently suffers any loss, then it is his fault, and that is because of his own negligence, and so the company will not be held liable in those circumstances. So basically, Doctrine of Constructive Notice ensures and protects the company from the claims of outsiders. Now, Doctrine of Indoor Management is just the opposite of this, which means that here the outsiders are protected from the irregularities of company. Now let's understand this. Let's come back to the case of British Royal Bank versus Turquand. So what happened in this case was there was a company, and the company wanted to borrow some loans. So they went to this. So they borrowed loan, and later the company became insolvent. And while they borrowed the loan, there was no internal resolution passed to obtain such loan. So after insolvency, during the insolvency proceeding, the company pleaded that there was no such resolution passed at all, and hence they are not liable to pay. But it was held that whether or not resolution passed is such knowledge that is only available for to the members of the company, that is to the insiders, and this is not something that outsiders are expected to know. This is not knowledge that is available in the public domain. So this was when the principle of, or the Doctrine of Indoor Management was evolved. And so basically it says that outsiders have access to certain documents like articles of association and memorandum of association and certain publicly available documents, but however they do not have access to those internal proceedings that happen within the company. If there are any irregularities on the internal management of the company, or certain required procedures or proceedings as it has not been met as they were supposed to, and as a result of that, if any loss has been caused to outsider, then they will be they should get protection in those circumstances, because they are not expected to know all this. So this is basically what Doctrine of Indoor Management is. However, there are three main exceptions to this doctrine. That is, in case of irregularity, that is knowledge of irregularity. So if the outsider is aware that the person in this company lacks authority, or there is some kind of irregularity, then he should not enter into that contract. Even after knowing that there is some irregularity, if he enters into some kind of a transaction, then he is taking risk by himself, and therefore he will not be able to get protection under doctrine of management. And um, the second one is forgery. So if you rely on a forged document for some transaction, even then you will not be able to claim any protection from doctrine of indoor management. And the third important one is negligence. Now, if there is negligence on your part, like if you did not go through all the documents, or if you did not exercise your judgment, and there was some part of negligence on your behalf, uh, and later you cannot claim that this is not later you cannot claim that this was not my fault, because there has been negligence on your part while entering into such transactions. Especially if you know that there is some suspicious circumstances surrounding the contract. If you know something is wrong, then you should not enter into a contract. And if you enter into such contract without making any enquiries, asking questions, and by knowing that there is something wrong, that is your own negligence. So you will not be able to get any protection under this doctrine. So that is all about doctrine of indoor management. I hope you all have understood today's video. I've also made other videos on various topics. Do check them out, and please like, share and subscribe to this channel, and press the notification button for more updates. Thank you.